Lincoln 103, 5 Lincoln 102, Lincoln 103 and 102.
Responding to 401 parking structure, section 1 boy.
Henry 8, Henry 9. Respond to gate 437, Bravo, for your dignitary detail. 3K 911 unattended, 400 lower level near Carousel 4, black bag. GTA in progress, 401 parking structure, section 4 boy.
Responding to 401 parking structure, section 1 boy.
415 passenger onboard aircraft.
Control 2 Franklin en route.
484 suspect, is female, Hispanic, 28 years of age, blue jeans, no further.
Control 5 Frank 401 is en route.
Hello and welcome to this edition from the legal side. I'm your host, Rick McCann, founder and CEO of Private Officer International. Today's topic is one that needs to be considered by law enforcement, private security, and public safety. Anyone having any type of authority needs to be aware and informed of the liability aspects of your job. So today we're talking about liability and why it's important to know what the liability is of our actions, what repercussions, what consequences can be assumed by us if we do something improperly or without legal cause. And we're going to be talking a lot today about the various type of liabilities. So welcome to this edition. Let's get underway. The court systems here in the U.S. generally recognize 4 different types of liability. And this is a class that we teach private law enforcement officers in multiple Southeast regional states and some security officer classes so that they're aware of what the court looks at to determine liability. First of all, what is liability? We hear the word a lot. You're going to be liable. Liability. Liability insurance. What is liability? Liability is similar to responsibility. Liability comes when we do some type of action that may be negligent or otherwise against law or against common sense. Liability is what we assume for our actions, both as an individual as well as a company or a law enforcement agency. If we use too much force, we can be liable for any injuries that the person sustains. If we use poor judgment and someone gets hurt because we didn't act fast enough, we didn't do the right thing, we didn't help them when we should have, we could be liable, and the courts could find liability against us. Liability is something that we need to be concerned about. We shouldn't, have it in the forefront of every situation. That's not what we want you to do. We don't want you to stop and go, oh my gosh, am I going to be liable if I do this? No. We want you to know what it is. We want you to be educated about liability. And we want you to understand that your actions could have consequences if they are incorrect or even sometimes when they are correct. So as I was saying, the courts in the U.S. recognize 4 different areas of liability. There is something called intentional liability. Intentional liability is assumed by the individual or their employer in some cases when you intentionally do something. You get upset on the job site. You're not happy with something your supervisor just told you. You're not happy with the way a situation went down. You're not happy because of some problem with your employer. Maybe you just got demoted. Maybe you didn't get a pay raise that you were expecting this week. And so you intentionally punch a hole in the wall of the client's office. You intentionally slam the door and the glass breaks. That's intentional. It wasn't by accident. It didn't just happen because. It was a direct result of your intentional actions. You meant for it to happen. You knew it was going to happen. You knew what you were doing, and thus it is intentional. You take a company vehicle that you're not supposed to have, and you drive it off while you're intoxicated and hit a pole. That's direct, intentional. You knew it was wrong, but you did it anyways. That is a form of liability that is unquestionable and one that doesn't have much of a defense should you have to argue it in court. You would have to prove that you didn't mean to do it. When all the evidence, all the witness statements, all the testimony points to the fact that, yes, we have no doubt in our mind that this was an intentional act. Intentional liability. There's something also in the law, one of the categories that the court recognizes is called strict liability. Strict liability means that there is no defense, there is no argument, there is no way out of it. They know that you were the individual that poured the chemicals into the water supply and caused others to be injured. They know without a doubt that you were the one that brought the brownies that was laced with marijuana that 30 people in the company got sick off from. There's no argument, no defense, no way, Jose, no way out of it. It's strict liability. You have no defense, and all they have to do is prove that you were the one involved, you were the one that did it. They don't have to prove that you didn't really mean to hurt anybody. They don't have to prove that you didn't really, wasn't your intention. It doesn't mean that, you just, it was an accident. No. There's no way that you're going to get out of it because it's a strict liability. They have proven that you were the one, and now there's no reason, no explanation that could justify your actions. This is exactly what is used in lawsuits against major companies and smaller companies when a supervisor intentionally does something or directs their staff to do something that they know is wrong. As a security supervisor or manager, you know absolutely that your client does not want you to carry firearms. But you bring firearms and you allow your officers to carry firearms on the property because it's dangerous. It's a bad neighborhood. We've had some incidents. Some of our people almost got shot, almost got injured. And now you've authorized as a supervisor, manager, or owner of the security company your employees to carry firearms in violation of your own written agreement or the agreement that you verbally made with your client. Now, when there is an incident, even if you are defending yourself with your firearm, this would be a strict liability situation. You knowingly violated the contract. You knowingly maybe even violated the law by carrying firearms and you didn't have the proper credentials to be armed, but you did it anyways. Then you got into a shootout. Then you injured or killed another. And when the company and the employees get sued, and they will, this is strict liability, no argument, no defense. You broke the contract. You broke the law. You broke the agreement. And despite the reasons, there's no defense under the law. Strict liability. The third liability that the courts recognize, it's called negligence. And this is one of the areas of lawsuits that companies get sued for most often. You were negligent in your actions. You were negligent and without due regard for public safety. You were negligent in your thoughts and processes, and someone else was injured or killed. You knew, for instance, that the speed limit was 30 miles an hour. But driving the company vehicle, you're in a hurry. You're late. Or maybe you're even responding to a call for service, a fight at an apartment complex. But without the authority of the law, you decide to speed up. And instead of doing 30, you're doing 60, 70, 80 miles per hour, and you're involved in a collision. Somebody gets hurt. Somebody dies. Your company and you, the individual, were negligent in your disregard for public safety, in your reckless driving, in your reckless manner, and the consequences that you're going to face will be substantial, both criminally and civilly in court, as you face both reckless driving, possibly misdemeanor or felony death by motor vehicle, and even more severe penalties, and then civil trial for your negligence that caused those injuries or, tragically, even the loss of life. Negligence. You're intoxicated. You're working nightclub security. You're drinking on the job. You get into a fight and you hurt someone. Police are called. In the report, they put down, we smelled alcohol on the security officer's breath. His eyes were glassy and watery. His speech was impaired, and he was under the influence of alcohol. Guess what? You were negligent in your duties. You were negligent in your actions. You were negligent by being under the influence while in uniform on duty. And if you're carrying a firearm, then that's an arrestable offense, even if you weren't doing anything but defending yourself. Now we have reckless conduct with a firearm because you're under the influence of drugs or alcohol. Negligence is something to take very, very, very personal and to understand it's very serious. It's a serious aspect of the law that will not be tolerated. I'm telling you now, if you hurt someone because of your reckless, negligent conduct, there's really no defense and no argument, no way to get out of it. You could face very long periods of time in jail or prison and definitely be sued along with your company. Negligent operations of a vehicle, negligent decisions. Negligent is something that you may not have meant to do it, but you did it in such a reckless manner that you were negligent. And the last area of liability that the courts look at in the U.S. is called vicarious liability. And vicarious liability, this is for all of you supervisors, managers, frontline people in charge, because this is an area of the law that is meant for you. And when we come back from this break, we're going to be talking more about vicarious liability and how it comes right down to the person in charge, even when you're not there, even if you didn't know about it, even if you never told the employee to do it, you, my friend, are going to be held liable in the court. We'll be right back after these messages.
From coast to coast, cops are cracking down on seatbelt violations. Buckle up day and night or expect a ticket. It doesn't matter who you are or where you live, they'll be on the lookout. Cops write tickets to save lives. Click it for ticket.
27 Jack, both the victim and the suspect here on 3rd Street, just 134 be advised, 3rd Street, please send a contact with the suspect and the victim. Just west.
They say if you want a wish to come true, never tell anyone. But there is one wish that can make the difference between life and death. And this wish can only come true if you tell someone. Please, let your family know you want to be an organ donor.
All right, welcome back to this edition of On the Legal Side. Before the break, we were talking about the fourth category of liability recognized by the court for not only security companies, not only private officers, public safety and law enforcement, but also for any business. It doesn't matter if you're a painter, a carpenter, a home builder, an auto mechanic, whatever type of business you have, every frontline supervisor, operations manager, district manager, or owner can face vicarious liability. And vicarious liability passes that liability down the line from supervisor to manager to regional to owner, president of the company, all can be sued for vicarious liability. When an employee does something, negligent, reckless, whatever they might do. Maybe their conduct was unbecoming. Maybe it was pathetic and just outrageous. The employer and the manager on duty at that time can be held liable. They can be sued for vicarious liability. Think of it this way. Vicarious liability is like you being a parent of a under 18-year-old child. Even though you're at home asleep, 2 o'clock in the morning, your child has snuck out of the house, taken your car keys, went for a joyride, picked up their friends, had a couple of beers from 7-Eleven, crashed into another vehicle that was parked on the side of the road. Nobody's hurt, but you are liable for the damage. On the other hand, that same child has a car accident. He's not supposed to be out. He doesn't have a driver's license, and he hurt somebody. Again, you're going to be liable as a parent, even if you didn't know about it, you didn't authorize it, you were asleep, you thought they were asleep. Doesn't matter. The court says you are liable as the parent. That liability falls to you. Same thing with vicarious liability. Whatever your employees do, you are responsible. The supervisor on duty at that time, the manager on duty at that time, and the owner who's home in bed asleep is liable for the actions of all of their employees. we get the credit when the employees do something good. But we also take the blame, the fault, and accept the responsibility when our employees do something they shouldn't, when our employees hurt, injure, or kill somebody, when our employees wreck the vehicles. We assume that liability. We assume that responsibility. We assume the financial loss that it's going to take because we have to replace or repair the vehicle. It all falls back to us as the owner, manager of that company. Liability is not something to be taken lightly. And I know that many of us have been in situations where employees of ours have taken it lightly, have shrugged it off, and even some management personnel not taking it serious, shrugging it off. I've had numerous employees and management say, "Isn't that what insurance is for? Don't you have insurance, boss?" Yeah, you're fired. I've got insurance and we'll take care of it, but you're out of a job. Insurance isn't the end-all, be-all blanket of coverage that allows you to do whatever it is. Hey, don't worry about it. We got insurance. Drive the car 150 miles an hour if it goes that fast. Drive reckless. Drink and drive. Don't worry, we got car insurance. Hey, I know the boss got insurance on the vehicles. Let's do it. No, it don't work that way. Even though we have insurance on the vehicle, you can still be sued. And we can sue you as well as an employee. We'll accept the responsibility. We'll accept the liability. We'll accept the financial responsibility. But one way or the other, it could come back to you, and you would be responsible for the financial losses that the company has to pay out. So let's talk about a couple of situations that we've noticed recently. Not really recently, but we've been noticing for years, actually, especially in the nightclub business. We just had a situation this past week where a nightclub security team, and I don't know if they were contract, if they were in-house bouncers, if they were licensed, unlicensed, I don't know, and it doesn't matter in this story, actually, but they had a fight inside the club. And as often happens when fights and problems occur in the club or even in the restaurant, the first thing security wants to do is separate those involved from the club, from the rest of the customers. And I understand, and that's, it's good. We need to get them outside. We need to have the disturbance removed so that other customers are not involved. They're not disturbed. It doesn't interfere with them eating or dancing or having a good time. So removing them outside is all good and well. However, what happened this past week, as has happened many times, is that the club security removed them to the parking lot and then went about their business. A shooting occurred, a person was killed, and now the police are conducting an investigation as to the conduct of the security officer or officers to see if what they did actually caused the shooting. Because putting 2 or 3 people or a group of people out to the parking lot doesn't always eliminate the problem. In fact, usually it escalates the problem because now they're outside of where security is monitoring and security is getting involved and separating. And now they are able to go at each other. And as you and I both know, it's not like it was years ago when it's all fist to cuffs and it's all hand to hand. Now it's boom, boom, boom. The first thing people are going to do is start firing shots, and people are going to die, as was the case here. So now police are investigating whether or not the security actions actually caused the death of the man. And if so, they could be charged. They could be charged themselves. many states have laws where you don't have to fire the gun. You don't have to shoot and kill the person to be charged with murder. You can be charged in many states because of your reckless conduct or you knowing or participating in that criminal act that caused the death of that person. The other issue, of course, is going to be civil liability. If you know that these 2 people or 3 people are having a problem, if you know and hear threats being made, and then you put them out of the club, the restaurant, the business to be killed, now you have a big lawsuit on your hand. And again, you could assume that liability. And I believe in this situation, negligence definitely played a part of it. You're negligent when you knowingly put somebody out that places them in harm's way. Of course, this is going to be something for the courts, juries, judges to decide. But our actions have consequences. And before you put people out of the business, before you put both sides involved in a fight, in a threat, back out into the public parking lot where somebody might get seriously hurt or even killed, we need to consider the consequences. The right thing to do is to separate them, put one group out, tell them to leave the property, and once they do, then put the other group out or the other person and tell them to leave the property. Now you have safeguarded the victim or the suspected person who's going to be the victim, the one who's going to get the worst end of it. You've safeguarded him. You've separated those involved, and you've reduced the possibility of any other interaction between them, at least at this time. You've reduced the possibility of injuries, deaths, and you've done your job. But just to leave, just to put them outside, just to say, oh, it's all good, no. It might be all good inside, but you are responsible for the actions that might cause someone to be injured or killed. You are also, in many places, liable for the parking lot. If it's a standalone building and it's not in a shopping center, then you're liable for the security outside as well. Even though you may have been hired for the inside, the business is liable for their property outside as well. There's a lot of liability in the security business. People don't think about it. They don't really, investigate it. They don't learn about it. They don't dwell on it. But there is a lot of liability that you need to consider. This is going to do it for this edition of From the Legal Side. My hopes is that you'll investigate what liability is and what liability you assume. And in closing, let me just say this. Just because you're a security officer making $10, $12, $15 an hour doesn't mean you cannot be sued or you can't have a judgment against you that's good for 20 years. One way or the other, if you get sued and a judgment is placed against you, that person will collect from you, whether it's take the money from your bank account, have your car towed and sell it. There's a lot of different options that lawsuit winners have when a judgment is given to them against another party, another company, or both. So be smart, think about your actions, and as always, be safe, be blessed, and we'll see you back here on the radio.